Thank you everybody for joining us for today's phone conference series. Today is the first in our series of trademark phone conferences, and we're going to be discussing 10 essential trademark tips. My name is Erik Pelton, and we are attorneys at the firm of Erik M, Pelton Associates in Falls Church, Virginia. I've been a trademark attorney for 12 years now, 10 years in private practice after starting my own firm, and prior to that I spent 2 years working at the U.S. Patent and Trademark Office. Our firm has registered more than 1,000 trademarks for clients from 48 states and all around the world. And also joining us is our associate, Mark Donahue.
Hello, I'm Mark Donahue. I'm a second-year trademark attorney and associate here with Erik Pelton Associates. I graduated from George Mason University School of Law, and also started working here during my third year as a student there. And then prior to law school, went to University of Notre Dame undergrad and have a master's of systems engineering from George Mason as well. And it's going to be a pleasure speaking with you today.
We've got a lot of really valuable and useful trademark information to share with you today. In addition to the 10 different trademark essentials that we've got a bonus tip for each section, and we're going to take questions at the end. So hopefully save up your questions for the end. We will unmute the lines and take questions then. I want to remind you briefly that this is not formal legal advice. This is merely for informational purposes. If you have any specific trademark or other legal questions, please consult an attorney. And we're going to jump right in now. Mark will cover the first of our essentials.
All right. Well, the first issue is the fact that not all trademarks are created equal. There are strong trademarks and weak trademarks, and the strength of a trademark dictates how well it can be enforced against others and how close others can get to you in competition with their services. So this scope of protection that you're getting with your trademark is often dictated by the words you select for the mark itself. All right? And they're classified on this scale of strong to weak, and I'll go through the categories here. So just a brief rundown. You have your fanciful marks, your arbitrary marks, your suggestive marks. Those are the strongest. And then your weakest are your descriptive marks and your generic marks. So a fanciful mark is an invented term. It's something created just to be a trademark. It doesn't have a dictionary definition. Isn't something someone else would have a legitimate reason to use. So for example, Verizon or Singular are terms those companies created to designate their services to others. If someone else goes out and tries to sell cell phones with a word that's very close to Verizon, the Verizon would have a pretty good argument that those people are trying to trade off of the goodwill and reputation of Verizon. And so those fanciful, invented terms have the very strongest protection. There's also, next on the list, are arbitrary marks. Now these aren't invented terms, but they are terms that have no direct meaning in relation to the goods or services that they're used with. So a good example here is Apple. Apple computers. Apples exist. It's a word. It's a dictionary object that everyone's familiar with, but it's not something that has anything to do with computers. And so that's also a very strong term. If someone else is using the word Apple with computers, it's a pretty good argument that they're encroaching in on Apple's protected sort of space. Now, if someone used the word apple for an orchard, it'd be a different deal. They'd have some legitimate reason to be using that term, and so it'd be less strong if it's used on goods or services that are connected with the word in some way. Now the third of the strong ones are suggestive marks. And those are marks that don't immediately describe the services or goods or something about them, but they give an impression about the goods and services to the customer as soon as they see them. A great example of this is the new car from Nissan called the Leaf. It's an electric car, and Leaf carries with it a message about the environment and having a light carbon footprint and being environmentally responsible. And that's an impression that they chose that mark to convey to their customers. Now, that does have some bearing on the product, to that extent, but it still is a pretty strong mark with, a good suggestive quality. So the meaning of the mark has some meaning on its own that doesn't have to be conveyed entirely through the advertising. People get it right away. Now, those are all strong marks, but below those, in the level of protection, there's two other categories. The first of those is descriptive marks. And descriptive mark is something that directly says something about the services. So an example of a really descriptive mark would be like Bank of America. It's a bank and it's in America. Descriptive marks generally aren't allowed to be registered at the U.S. Patent and Trademark Office. The only way they can be registered is if the applicant shows that through advertising and efforts, people have begun to associate that descriptive term only with them. And so Bank of America had to do some extra work in order to get a registration for their mark. And their mark gives them a narrower scope of protection. If you opened up a bank tomorrow and called it America's Bank, Bank of America might complain, but they might have they might have weaker rights to stop somebody because America's Bank is also in America and it's also a bank. Whereas, if they had a stronger mark, their rights would be better and easier to enforce. And finally, there are generic terms, and generic terms can never serve as a trademark. They are terms that are intended to be available to anyone in the public because competitors need them to describe their services. And generic terms are the name of the goods or the services. Car for cars, bank for banking. No one can claim exclusive rights to those marks because they don't designate a specific provider of services, and they need to be made available to others. And so that's kind of the continuum. And then there's other factors that can affect the strength of your mark. Like if you've become famous through large sales or advertising, your mark is stronger. And if other people are using similar marks for similar goods or services, your mark gets weaker. And these are all the factors that come up when someone gets into a trademark dispute and when someone's deciding whether or not a trademark is available. So a bonus tip on the strength of marks is, at least we believe, that suggestive, creative marks, like Leaf for an electric car, are probably the best marks out there. You want to carefully pick something that is available and isn't like others, but also gives an impression about your goods to customers, so that you don't have to do all the legwork through your marketing to tell them what your mark means. A good example of this would be the new Starbucks Via Ready Brew Coffee. Via conveys on the go, fast, portable, and it doesn't force Starbucks to spend all their time telling customers what their product is. And so that's the rundown for strength versus weakness of marks. Our second issue is proper trademark use. Whether or not you have a strong or weak mark, you also need to use it in the proper way. And so, this goes down to what the purpose of trademarks are. Trademarks exist to specifically identify a single source of goods or services, who the provider is. And so you need to make it clear when you use your trademark that that's what you mean for it, that's what you mean to convey, that only you have the rights in it. So the basic thing about this, make it stand out. Don't bury it in sentences, make it bold, put it in a logo, put it at the top of advertising materials, at the top of your web pages. Make it clear to people that you are claiming rights in this term and that no one else can use it the way you do. Use proper trademark notices, and you've probably seen the TMs and the SMs and the R with the circle around it. These are also ways that people indicate to others that they claim sole, exclusive use in those terms. TM is what you use for a trademark that isn't registered at the Patent and Trademark Office, and that's for goods, if you sell products under the mark. SM is for a service mark, which is the same as a trademark, except that you're selling a service. Plumbing services would be a trademark that uses an SM, and say selling pipes for plumbing would be a TM, for example. And then instead of either of those, if you've become registered at the Patent and Trademark Office, you can use your mark with the R with the circle around it. And that's a stronger notice that you can use, and that's both for goods or for services. Another important thing about using your mark properly is you want to avoid your mark becoming one of those super weak generic terms. You don't ever want to use your mark in a way that conveys to people that it's the type of product you're selling and not the source of the product. So you'll see that a lot of companies go out of their way to make this clear. Kleenex brand tissues is on every Kleenex box. Xerox brand copiers. They're using their mark and following it with the generic term for what the product is. And this makes it clear to the public that they're not selling Xeroxes and they're not selling Kleenexes. Because if that were the case, other people, competitors, could sell Kleenexes too. No. Competitors sell tissues. Kleenex also sells tissues, but only Kleenex sells Kleenex brand tissues. Also, another important thing is you got to make sure not to use your mark solely as an ornamental thing. Nike has the big swoosh on the front of their shirt, but trademarks aren't ornaments. Trademarks aren't things that are decorative solely. The swoosh is decorative, but Nike also has that swoosh on the hang tag in the neck or in other product packaging that shows that that swoosh means this shirt comes from Nike, no matter what's on it. And so, bonus tip for proper trademark use is include information about how trademarks are supposed to be used, who owns trademarks, in your agreements with the people you deal with in your business. Employees, officers, suppliers and distributors, particularly franchisees, and also customers. And it's a common thing to include in terms of use, say for your website, that users have to agree to when they start using your services there. And so for the next issue, we'll throw it back to Erik.